Hello everyone, welcome back to our Learning English through Case Law series. In this video we will study Case number 50/2021/L, regarding the right to initiate lawsuit to reclaim property assigned by an effective judgment, decision. Including 5 parts: Part 1, Source of the Case Law; Part 2, Overview of the Case Law; Part 3, Content of the Case; Part 4, Assessment of the Court; Part 5, Rules. This case law was approved by the Council of Judges of the Supreme People's Court on November 25, 2021 and announced in Decision Number 594/QDCA dated December 31, 2021 of the Chief Justice of the Supreme People's Court. Case law source: Cassation Decision Number 481/2012/DSGDT dated September 25, 2012 of the Civil Court of the Supreme People's Court on the case Dispute for Reclaiming Property in THEO Province between the plaintiff Mr. Nguyen Van An and the defendant Mrs. LUient T. Part 2, Overview of the Case Law. Case law context: a legally effective judgment or decision of a court dealing with the division of properties, but this judgment or decision has not been enforced because the judgment creditor has not requested for judgment enforcement and has not yet actually received the property. When the statute of limitations for requesting judgment enforcement expires, the person to whom the court has assigned the property raised dispute to reclaim the assigned property according to the aforesaid judgment or decision. Legal solutions: in this case, the court must determine that the person who has been assigned the property according to the legally effective judgment or decision of the court has the right to initiate a lawsuit to reclaim the property. Keywords of the case law: there has been a legally effective judgment or decision on property division, the statute of limitations for requesting judgment enforcement has expired, the right to initiate lawsuit for reclaim of property. Part 3, Content of the Case. In the petition dated January 4, 2005, plaintiff Mr. Nguyen Van An presented, Mr. and Mrs. Nguyen T got married in 1963, they have a house located on a land plot in Village B, Commune X, which is now the house on 04H Street, Area 8, Ward C, Hugh City, with area of 1,490 square meters. In 1968 Mr. An escaped to the north. In 1975, when Mr. N returned to his hometown, Mrs. T had another husband, so they applied for a divorce. In the Appellate Civil Judgment Number 43/DSPT dated May 13, 1977, the People's Court of Binh Tri Tien Province granted Mr. N and Ms. T a divorce. In terms of property, Mr. N has the right to use a part of the land which contains the grave of Mr. N's father, the boundary drawing by the court attached to the judgment. After the appellate judgment took effect, Mr. N fulfilled his child support obligation, and the authorities measured and divided the land according to the court's drawings. In 2001, Mr. N returned to his hometown to build an ancestral shrine, but got hindered by Mrs. T, so he filed a lawsuit to ask Ms. T to return the property, which is the land use right according to the judgment, asking Ms. T to restore the status quo of the boundary as specified in the court's judgment. Defendant Ms. Nguyen T admitted to marrying Mr. N, then divorced according to Judgment Number 43 dated May 13, 1977. In 1968, Mr. N went to the north, and in 1969, he received a death certificate of Mr. N, so Mrs. T married another husband. Since the date of the judgment debtor Mr. N has not filed a request for judgment enforcement, so Ms. T refuses to return the land to Mr. N because she believes that the land was given to her by her father. In the first instance civil judgment number 08/2006/DSST dated June 21, 2006, the People's Court of HIliwoCity, THEO Province, decided. Accepting the request of Mr. Nguyen Van N, force Ms. Nguyen TT to return the land use right with an area of 452.85 square meters, with side 37.5, 38.55, 36.14, which is the property established under judgment number 43/DSBT dated May 13, 1977, on which stood the grave of Mr. N's father in land plot number 42, cadastral map number 28, with an area of 1,997.06 square meters at the house at number 04 H Street, Area A, Ward C, HIliwoCity. The location drawing of Mr. N's land plot is attached. In addition, the first instance court also decided the court costs and the right of appeal of the involved parties. After the first instance trial, Ms. T appealed. In the appellate civil judgment number 55/2006/DSBT dated December 11, 2006 of the People's Court of THEO Province, decided. Annul the entire first instance civil judgment number 08/2006/DSST dated June 21, 2006 of the People's Court of HIliwoCity, THEO Province on the dispute for property and land use rights between the plaintiff Mr. Nguyen Van N and the defendant Mrs. Nguyen TT, terminate the settlement of the case. Returning the petition to Mr. Nguyen Van N. In addition, the Court of Appeal also decided on the court fees. After the appellate trial, Mr. N complained. At the protest decision number 708/2009/KNDS dated December 10, 2009, the Chief Justice of the Supreme People's Court protested against the appellate civil judgment number 55/2006/DSBT dated December 11, 2006 of People's Court of THEO Province, with the comment, Mr. N's land use right was determined in the appellate court number 43/DSBT dated May 13, 1977. Mr. N has the right to sue for property in a new civil case. The appellate court determined that Mr. N did not have the right to sue and returned the petition to Mr. N was unreasonable, proposing the Civil Court of the Supreme People's Court to open cassation trial to abrogate the above-mentioned appellate civil judgment and abrogate the first instance civil judgment number 08/2006/DSST on June 21, 2006 of the People's Court HIliwoCity, THEO Province, transfer the case files to the People's Court of HIliwoCity, THEO Province for retrial in accordance with law. At the cassation hearing, the representative of the Supreme People's Procuracy agreed with the protest of the Chief Justice of the Supreme People's Court. Part 4. Assessment of the Court's findings. 1. Based on the documents contained in the case files, there are grounds for conclusion. Mr. Nguyen Van N and Ms. Nguyen TT got married in 1963. Mr. and Mrs. N and T had a house located on a land plot in Village B, Commune X, which is now the house number 04, Street H, Area A, Ward C, HIliwoCity, with an area of 1,490 square meters. In 1968, Mr. N escaped to the north. In 1975, when he returned to his hometown, Mrs. T had another husband, so they requested for a divorce. 2. In the appellate judgment number 43 dated May 13, 1977, the People's Court of Binh Tri Tien Province settled Mr. N and Mrs. T's divorce, decided on the responsibility of nurturing and dividing the property. According to the judgment, Mr. N was entitled for a part of the land, boundary map drawn by the court attached. Due to the impact of working far from home, Mr. N left the land as it was. In 2001 he returned to his hometown to build an ancestral shrine, but hindered by Mrs. T, the two did not agree on the land boundary and Mrs. T refused to give the land to Mr. N. Therefore, Mr. N initiated a lawsuit to request Mrs. T to return the land according to the legally effective appellate judgment. 3. In fact, up to now, Mrs. T has been the keeper and user of the land that the People's Court of Binh Tri Tien Province has assigned to Mr. N. According to Mrs. T, Mr. N has not filed an application for an enforcement of the above judgment and the judgment has not been executed. now the statute of limitations of which has expired according to the law. For, according to the law, Mr. N's land use right over the disputed land was determined in the Appellate Judgment Number 43 dated May 13, 1977 of the People's Court of THEO Province. The courts cannot re-examine who is the lawful owner of the land, but a lawsuit to reclaim the property is another legal relationship. If the statute of limitations for judgment execution has not expired, Mr. N had the right to request the enforcement agency to enforce the land transfer according to Judgment No. 43 dated May 13, 1977 of the People's Court of THEO Province. However, when the status of limitations expired, Mr. N had the right to initiate a new civil case to reclaim the property. In this case, if there is no basis to determine that Mr. N has abandoned the usage right over the property, the request for initiation of Mr. N must be received. 5. The appellate court judged that Mr. N did not have the right to initiate the lawsuit, returned the petition to Mr. N was groundless. On the other hand, the court has not verified, considered the land management, using, declaration and tax obligation, opinion of the state agencies to recognize or not to recognize the lawful use right to this land. 6. The first instance court accepted Mr. N's request to demand Mrs. T return the right to use the land with an area of 452.85 square meters as the property determined according to Judgment Number 43/DSPT dated May 13, 1977 on which stood the grave of Mr. N's father, but did not take into account the work of Mrs. T on keeping, preserving, cultivating the land as well as the tax amount Mrs. T paid for the land is wrong. The appellate court annulled the entire first instance judgment of the People's Court of HIɾU City to suspend the settlement of the case, returning the petition to Mr. N was not in compliance with the law. 7. Therefore, the protest of the Supreme People's Court is grounded for acceptance. 8. By the above reasons, pursuant to Clause 2 Article 291, Clause 3 Article 297, Article 299 of the 2004 Code of Civil Procedure, amended and supplemented in 2011. Part 5. Abrogate the entire Appellate Civil Judgment Number 55/2006/DSPT dated December 11, 2006 of the People's Court of THEO Province and abrogate the entire First Instance Civil Judgment Number 08/2006/DSST dated June 21, 2006 of the People's Court of HIɾU City, THEO Province on the case dispute for reclaiming property between the plaintiff Mr. Nguyen Van N and the defendant Mrs. Nguyen TT. Transfer the case file to the People's Courts of HIɾU City and THEO Province for retrial in accordance with law. Content of the case law. 4. According to the law, Mr. N's land use right over the disputed land was determined in the Appellate Judgment Number 43 dated May 13, 1977 of the People's Court of THEO Province. The courts cannot re-examine who is the lawful owner of the land, but a lawsuit to reclaim the property is another legal relationship. If the statute of limitations for judgment execution has not expired, Mr. N had the right to request the enforcement agency to enforce the land transfer according to Judgment No. 43 dated May 13, 1977 of the People's Court of THEO Province. However, when the status of limitations expired, Mr. N had the right to initiate a new civil case to reclaim the property. In this case, if there is no basis to determine that Mr. N has abandoned the usage right over the property, the request for initiation of Mr. N must be received.